Plaintiff's reply to docket number 48 court order. Attention Judge J.P. Stadtmuller and the Federal Clerk of Court for the United States District Court, Eastern District of Wisconsin. I, Plaintiff pro se in this legal matter, am filing this here plaintiff's reply to docket number 48 court order for submission of actual lost ad revenue jurisdictional discovery statements to be submitted by June 16, 2022. There is no way the plaintiff will be able to supply this information. As I have stated previously, only the defendants can provide this information. It is not as though the defendants sent quarterly statements detailing how much of my ad revenue shares the defendants intentionally stole, as my videos were incessantly flagged, unflagged, and reflagged repeatedly for nearly half a decade. This court order also appears to be a ploy, giving the defendants an opportunity to provide any amount in actual lost ad revenue the defendants so choose, no matter how minuscule, in order to nullify proper subject matter jurisdiction and venue, which the United States District Court for the Eastern District of Wisconsin currently has over the plaintiff's lawsuit due to the amount in controversy, $25 million in punitive damages and diversity of citizenship of all parties. Also, Judge Stadtmuller, when comparing your statements between Court Order Docket number 31 and Court Order Docket number 48, you appear to continue to make statements leaving out pertinent information actually stated by the plaintiff, including the large amounts in digital evidence submitted by the plaintiff. Despite my observational opinions, I would just like to state that it appears more and more apparent I am not going to be awarded my demand for a jury trial, as I believe a fair and impartial jury will view my lawsuit differently based on the collected evidence. Judge Stadtmuller, the plaintiff's lawsuit seeking punitive damages is awardable under Wisconsin law if evidence is provided proving the defendant's actions were egregious, malicious, and high-handed to intentionally harm the plaintiff. Again, the plaintiff stands by the evidence submitted, which there appears to be in an attempt to block the plaintiff's evidence never to be witnessed by a fair, unbiased, and impartial jury. Lastly, Judge Stadtmuller, I, the plaintiff pro se in this legal matter, stand by all claims stated in the first amended complaint, docket number 19, submitted evidence, arguments via briefs in opposition to, and all cited legal sources contained in the plaintiff's opposition brief to the defendant's motion to dismiss for failure to state a claim, docket number 28 and docket number 30. Reply letter to court order document number 31, docket number 35, see also docket number 42. Subject matter jurisdiction brief, docket number 39. Response to Defendant Alphabet Incorporated's proposed statement of facts, docket number 43. And reply to Defendant's docket number 44, additional statement in support of the defendant's subject matter jurisdiction brief, docket number 45. Currently, there are 3 issues stagnating the progress and final outcome of the plaintiff's lawsuit against the defendants. 1. Defendant's pending motion to dismiss for failure to state a claim, docket number 25. 2. An official ruling on subject matter jurisdiction briefs, docket number 38 and docket number 39. 3. Court order jurisdictional discovery actual lost ad revenue statements, docket number 48. Motions filed by the plaintiff that went unanswered. 1. Motion to proceed without paying the filing fee, 271 days and no answer, docket number 2. Retraction statement of motion to proceed without paying the filing fee, docket number 6. 2. Motion for judgment by default, docket number 18, filed due to plaintiff never being informed or served. Defendants filed motion for extension of time granted in 1 day, docket number 15. Despite the 3 above pending issues currently at hand, if the plaintiff's lawsuit is dismissed and the plaintiff is denied the demand for a jury trial to simply show a jury the submitted evidence and present the plaintiff's stance on the evidence, the plaintiff fully intends to file an appeal to the higher court, the United States Court of Appeals for the 7th Circuit, even if the plaintiff's lawsuit is dismissed without prejudice, to be filed in state court based on the information contained in the defendant's jurisdictional discovery statement on actual lost ad revenue, which the plaintiff does not have sufficient information to provide an honest statement and would have to solely rely on the information provided by the defendants, which the plaintiff has zero confidence in. Thank you. Page 3 of docket number 48, the court ruled against the plaintiff's 3rd amended complaint, again citing the plaintiff's 1st amended complaint as the operative complaint, and due to this latest ruling, Alphabet Incorporated has been listed again as a defendant within this document and in future filings. See attachment 1 of 1. This is my personal opinion on the true intentions for the docket number 48 court order. I honestly believe the assigned judge created this court order to give the defendants the opportunity to dictate any amount in actual lost ad revenue shares allegedly lost by the plaintiff in order for the judge to predetermine and change the amount I, the pro se plaintiff, am suing the defendants for in order to make a final ruling to dismiss my lawsuit without prejudice, to have my lawsuit moved from federal court to state court. This is another display of disgusting bias by the assigned judge, due to the judge knowing very well that I cannot provide this information. This is why I intend to file an appeal for any final judgments to dismiss made by J.P. Stapmuller. Why is the judge stalling? If the assigned judge truly believed the defendant's motion to dismiss for failure to state a claim succeeded, my lawsuit would have been dismissed on that basis. Instead, the judge files a court order for subject matter jurisdiction briefs to be filed by all parties. If the judge truly believed I failed in proving subject matter jurisdiction, my lawsuit would have been dismissed on that basis. Now, the judge files a court order requiring all parties to file statements proving actual lost ad revenue amounts that puts control in the hands of the defendants to dictate any amount the defendants so choose that can potentially alter the course of my lawsuit. Now do you understand why I prepared my appeal papers shortly after filing my lawsuit against the defendants? No matter how sound and truthful my presented arguments are, the assigned judge refuses to accept anything I have to say or submit to the clerk of court, and accepts anything filed and stated by the defendants.